Yes, my Lord, and those are the affidavits we are talking about. And the law is that they are not struck out preliminary at this stage. And my Lord, I will now go to the last one before I address specifically that issue, because the PO is premature. And we are going to submit why it is premature. But I would like to go to the last one, who is Chamber Nathan. So my Lord, on the first two, Ntale Mukasa is not their witness, not subject to the PO. The second one didn't even swear. He's saying, I'm not recanting because I've never sworn. That one cannot also be called a recanting until court presents to me. The third, who is Nathan Moambuzi Chamber. My Lord, this one is the one that falls under what we call recanting witnesses. Recanting witnesses. And recanting witnesses are not illegal. I want to submit on that. Recanting witnesses are not illegal witnesses. My Lord, in highlighting that, I would like to say that courts have held that in election petitions, like what we are dealing with right now, court is required to subject each allegation raised to a thorough and a high level of scrutiny, and to be alive to the fact that in an election petition in which the prize is political power, witnesses who are invariably partisan might resort to telling lies in their evidence in order to secure judicial victory for their preferred candidate. My Lord, that's what we are faced with in election petitions. It is an extension of the campaign. The campaign was ended, there was a declaration, and a new campaign has begun in court, where witnesses come with preconceived. So the jurisprudence of the country is that courts must examine each allegation. We are not arrogating sainthood on the respondent, and neither are the petitioners. My Lord, your brother, Honorable Justice Issa Serumpuma, in Kawempe Nambi versus Monsignor Francis and 3 others, Kawempe Nambi versus my brother's High Court Civil Suit number 96 of 2021. In citing the celebrated case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors, 1969 1 the court held, I will quote verbatim, for purposes of demonstrating to court that the criminal objection before court is not a criminal objection. It's premature. So far as I am aware, my Lord, that's page 6. Page 6 of the Kawempe Authority. And the second last paragraph is where I am. The court here noted that the question to be considered here is whether the preliminary objection raised is competent to be dealt with as such. The main principle governing criminal objections was considered way back in the case of Mukisa Biscuit, where court held that so far as I am aware, a criminal objection consists of a point of law which has been pleaded or which arises by the clear implication out of pleadings, and of which, if argued, as the prayer point may dispose of the suit. A criminal objection is the nature of a demurrer. It raises a pure point of law which is argued on the presumption that all the facts pleaded by the other side are correct. And my Lord, my emphasis is on this last part. It cannot be raised if any fact has to be ascertained. My Lord, before us, court has no evidence, has no proof of any tampering, any bribery, any coercion, any inducement of any of the witnesses. So that is a fact that must be ascertained by one person like me, a lawyer, standing and giving evidence from the bar when I'm not a witness, cannot amount to proof before court, because these are very serious allegations that border on professional misconduct. So this authority, which has been consistently cited and is still binding, says it cannot be a PO if there are facts that have to be further ascertained through eliciting of evidence, or if what is sought is in the exercise of judicial discretion. Now, what counsel for the petitioner wants court to do is exercise discretion between these two sets. Which one? My Lord, that ceases to be a PO. And we are submitting, my Lord, that the PO is not a PO and should be overruled and dismissed with us. If court be pleased. My Lord, the law provides remedies in these instances. And the remedies is what has been applied consistently, even in the authorities that is cited. As to whether the recanting is real or not becomes an issue for determination. And then evidence is led. And when court is finally determined, guided by the nature of evidence before it, it takes a decision, judicial. My Lord, with us, I conclude by submitting that this court be invited, to follow the binding decisions of the Supreme Court, which are stare decisis, in answering the question before it. And for brevity, my Lord, you sit on the bench, Justice Farida Fukirwa, in Uganda versus Ssegonga Musa. In Uganda versus Ssegonga Musa, in which he cited the Supreme Court's decision of Okwanga Anthony, versus Uganda, Supreme Court, Criminal Appeal number 20 of 2000. In answering the question as to whether the evidence of a hostile witness, my Lord, these are hostile witnesses in law. One who does this and tries to change a position are hostile witnesses. And hostile witnesses appear every day because to cross-examine the fellow and runs from his higher position and changes and say, I'm now ready to say the truth. That is not illegal. It is in fact kudos to lawyers and court for doing the right work to make justice out of whatever situation is before you. Court says here, what is the Supreme Court? My Lord, it is on that authority that we shared with court It's highlighted. And it was held that it is a settled legal position that the evidence.
Where are you reading from?
My Lord, page 3. Condición oxyglonga. The expression hostile witness does not find what the court there was quoting. Is going to mean testimony of a witness standing to depose in favor of the opposite party. We must bear it in mind that the witness may depose in favor of the party in whose favor it is meant to be given through his examination, while later on change his view in favor of the opposite side. Similarly, there will be cases where a witness does not support the case of the party, starting from the examination itself. This classification has to be borne in mind by the court. With respect to the first category, the court is not denuded of its power to make an appropriate assessment of the evidence. Such evidence will become complete after the cross examination. So once evidence is completed, the same testimony as a whole is meant for the court to assess and appreciate what facts. Therefore, not only the specific part in which a witness has stand hostile, but the circumstances under which it happened can also be considered. My Lord, just quoting also that the reason why the precedents have encouraged when those occurrences arise to subject the parties to cross-examination is for court to appreciate the circumstances under which the instances do arise.